Good evening, everybody. Thank you for coming in so big numbers. We're very happy that you are here. My name is SWOBODA. I'm president of the IAP and I want to welcome you. Many years ago, decades ago, I studied law and economics. And for me, then I went into politics afterwards here in the city of Vienna and the European Parliament. Law always was a framework for every activities. Whatever you do, you should respect the law because law is a guarantee for people's life, for people's activities, for people's rights, for people not to be killed, degraded, humiliated, and so on. So law is a basis, foundation of our democracies. So when we discussed recently in the break of some event about the law, and somebody said, well, politics is always more important than law. Maybe in reality that is often the case, but probably this shouldn't be the case. And some people would say, well, laws are never respected during wars and conflicts, and maybe this is true as well, but if and when laws are important and necessary, it is in times of conflicts and in times of wars. And as we have now many wars, especially 2 wars in our immediate neighborhood, in the Ukraine on one hand and the Middle East on the other hand, I think it's very important to insist that laws are not here to be forgotten, to be not respected, that laws are here to be respected. And for us as an institute, International Institute for Peace, it is very important that not only in peace, but especially in war, laws are respected. And therefore, it is very important. And we're very grateful for you two to come and to speak to us. And you will be represented and presented by Stephanie. Again, welcome. And I want to hand over to Stephanie, our director, who would moderate the discussion and have an interesting night. Thank you very much.
Thank you very much, Hannes, for the nice introduction. Also, very nice and warm welcome from my side. I'm Stephanie. I'm the director here of the International Institute for Peace. And I'm incredibly grateful and thankful that 2 of you agreed today to debate with me a topic which is very important, but also very contested these days. The topic today is Dead or Alive, the challenges of international law and international criminal law in the Middle East. You might already know the 2 speakers. Nevertheless, I'm going to introduce them. To my right, it's ASTRID CORACINI. I hope I say it right. She's from the University of Vienna, from the Department of European, International and Comparative Law, and an expert on international criminal law. So thank you so much for coming today. And we do have JANIK. I'm assuming many of you do know him as well. He's an international law expert from the Sigmund Freud Private University and also a member of the International Institute for Peace, which is this institute advisory board. Thank you very much, Ralf, for coming, and thank you also very much for actually giving me the initiative to hold this public discussion today. It shouldn't be like a very frontal kind of discussion. So the idea is that we discuss between ourselves a little bit, especially the 2 experts between themselves, about humanitarian law, international law in general, but also about international criminal law. But it's very important also to give you afterwards the floor to ask questions, and please do that without any restraint. So yeah, I look forward to that part as well. Hannes already mentioned there are 2 main wars ongoing, which are, I would say, of huge concerns for this part of the world. There are a lot of wars ongoing in other parts of the world, in Sudan. So I don't think we should forget about this as well. But obviously, especially the last 2 wars have raised many, many issues when it comes to the rule of law, when it comes to international law, pacta sunt servanda, when it comes to what is the International Criminal Court. We have been seeing arrest warrants against Hamas leadership, but also at the same meeting against Netanyahu and his, at that time still, defense minister. He's not yet defense minister. The Hamas leadership, the 3 of them are dead by now. This is like one issue we are going to tackle upon. What is actually in these allegations? What has the prosecutor is alleging them to have been committing. On the other hand, it is what Israel is claiming, that they're actually fighting a war against self-defense. So what is still in line with international law when it comes to self-defense? What can you do? What is the differentiation between combatants and civilians? And we do know that especially the wars in the Middle East, and I just said plural because there is also now a war going on in Lebanon, so the war is spreading, so we should not forget about this one as well. So it's a very dangerous situation. We don't know what is going to happen in the future. We do know Iran also plays a role, but then also the West does play a huge role. So I'm not going to speak a lot more, but I need to give you also a couple of figures. We all know that it did not maybe... the wars did start on 7th of October with the brutal massacre of Hamas against many civilians in Israel. It was for us, I would say, very traumatizing for the Israeli population. It was very traumatizing. But then we know what has been following later on. The war is going in a very, very brutal way. We're speaking about 43,000 dead people. Majority of them might be children and women. And then I already mentioned there is a war also ongoing in Lebanon with 1 million refugees already from the southern part of Lebanon, also 2,700 dead people already there. We have been hearing about the so-called Patriot attacks. Maybe we can discuss this as well. And nevertheless, there are still also hostages in Israel. So everything is a very, very complicated, very difficult topic. And I would like to kick off the discussion with you, maybe, Ralph. Maybe you can just tell us a little bit, when we talk about the international system, the United Nations Charter, how it all began. It was after the Second World War. We said never again, so we came up with this charter and somehow creating this kind of rules who should deal with not wars, because war essentially are prohibited, but there are some exceptions. So maybe you can just give us a very, very brief overview about what actually international humanitarian law means in the sense of what international law means when it comes to the conflicts I have just been now touching upon. And I think I didn't really mention Russia for the time being, but we can maybe also dive a little bit into that one.
Thank you for the kind words, and also thank you for the introduction.
It works.
Oh yeah, all right. I'll try to be as brief as possible because, as you can imagine, we could talk about that for hours. I saw some of my students here. You know that we have been talking about that for hours. The one thing I want to say and emphasize here, however, is that there are certain rules that are indeed, at least in the official rhetoric, unchallenged. So, for example, when you look at the speech by Vladimir Putin at the General Assembly from a few years ago, he emphasized the role of the United Nations and its principles as a cornerstone of the international system. Not too long ago, he also made that point again. You see that in the speech even by Donald Trump in his last UN General Assembly speech. Even he emphasized the importance of the United Nations. To my surprise, there was one of these COVID-19 speeches. It was pre-recorded, only 7.5 minutes, but nevertheless, during these 7.5 minutes, he emphasized at the very beginning that it was an honor to speak in front of the United Nations and how important the United Nations Charter is, and the United Nations as such are. So, interesting enough, although we have all this talk about whether international law is going to survive all these wars, whether international law even still exists, in the minds and rhetoric of states' leaders, it still exists. It seems as if it exists more than ever. So we see this strange paradox that the more often it is violated and the more obviously it is being violated, the more blatantly it is being violated, the more frequently states' leaders seem to refer to it. So there is a huge gap between theory and practice, but the theory, the wording, the rhetoric is still there. It seems as if it's more present than ever. The second point I want to stress at the beginning, and as I said, I'm trying to cut myself and be as brief as possible, knowing that I tend to talk way too much, that I'm meandering. The second point is that we see that the system is not designed for most of the wars that we see today. The system was designed for wars that take place between two states or more states, and ideally speaking, none of them would be either directly present as a permanent member in the UN Security Council, or at least not closely affiliated with a permanent member of the Security Council. It's not designed for wars like the one started by Russia against Ukraine, because there you have the veto power that can prevent any sanction or even the authorization of force against it. And it's also not designed for wars like the one in the Middle East, or the several wars in the Middle East. Why not? Because in the drafters' minds during the 1940s, they thought about interstate warfare. State A attacking states B, C, and D. They were negotiating the UN Charter during the final phase of the Second World War. So the Second World War was on their minds. It was predominant. Maybe it was the only conflict that they had on their minds. They didn't think of situations of de facto authorities, as they're called in a legal sense, like Hamas, having the capability of carrying out attacks that resemble attacks that are being carried out by states. They were not having in their minds terrorist attacks at such a large scale that they can be compared to traditional, with quotation marks, states' armed attacks. So the system is constantly developing and trying to adapt. So what sometimes seems as if it is making international law irrelevant might also be a transition or an adaptation phase to new actors such as Hamas, actors that were not in the minds of the drafters of the UN Charter. So my, let's say, somewhat hopeful, maybe naive assumption here is that the system is not collapsing, the system is changing, and it's changing tremendously. And it's changing in two ways, and then I'm going to stop. The first was that it's no longer, and has been changed for long, it's no longer focused on interstate warfare. It's increasingly, and that has been going on for at least 23 years, namely at least and ever since 9/11. It's adapting to new threats, terrorist threats. And the second one, and that's parallel, and that's a contrary development, it's also going back to the past. It's going back to the 19th century. I think that the textbooks, that's my personal opinion, I think that the textbooks that I bought from the 19th century that I have back at home in my bookshelf, the 19th century and early 20th century textbooks are, in some situations, more relevant than the modern international law textbooks, because we're moving towards a world that resembles the 19th century with a myriad of actors, with a complex system, no predominant power, and also, to some degree, no longer complete prohibition of the use of force, but states, they don't like the use of force, they don't like wars, but they have accepted the reality that wars may erupt, both between states and terrorist or other non-state actors.
Thank you, Ralph. Astrid, when you just listened to Ralph, he mentioned, I would say in the end, he mentioned there is actually something which is called prohibition of force. I mean, this is what we know. In essence, wars are not legal in any sense, but wars are still happening. This is just a reality. I mean, most of the time it is claimed to be a war of self-defense, which is one of the exceptions. And then we also know and we see that what happens during wars or violence or interstate wars or however they actually develop is that there are many gross human rights violations happening. It is not now the only time when it happened. I mean, we remember the Yugoslav wars, which have been very brutal. All of us remember also, for example, Rwanda. There are a couple of other, I would say, historical, not even that historical because it hasn't been that long ago where these mass atrocities happen. And then I have the feeling the international community thought we need to tackle that as well. And then this is something where I think international criminal law comes in. Or can you maybe explain me what is international criminal law, maybe to compare to what Ralph has just been saying. What is it? What does it contain? And why do we actually need something like international criminal law?
Thank you very much. Also for the invitation. It's really nice being here and discuss with Ralph. There are always so many points of discussion that we have. And maybe before I answer your question, just 2 points. So maybe the system was not designed for the development of types of armed conflicts that we have, but there's also nothing in the system that would impede it to deal with those kinds of conflicts. So I wouldn't accept that argument, and even less the one that it was not designed for armed conflicts in which one of the P5 would be involved, because I think that was exactly the idea of the veto power of the P5, that there would be 5 nations that would be immune and that they would judge over others, but they would preserve themselves. That was the essence of the Security Council as a political body. So just these 2 points. International criminal law. And you made the point that maybe we need it particularly now because of the atrocities and that we face, and the amount of non-state actors that are active in armed conflicts today, if I understood correctly.
Maybe not particular because of that, but maybe increasingly so.
Yeah. So when I look back at the development of international criminal law, the idea was always to capture individuals that act for states. Because if you have non-state actors, states have a very high interest in prosecuting those people. But there's not a lot of interest to prosecute organs of a state. So if we look at the system from outside and there was a need for or a wish for accountability, one looked at states primarily. And of course also partly because international law, as it was in the 1940s, 1950s, of course, was predominantly states that were in the focus. And also the experience from the Second World War. So if you look at the old drafts of the International Law Commission, it was mainly states and states' organs, and only slowly there was a discussion, could there maybe also be other perpetrators than state organs? And of course then it was opened, and today we see that we have mostly non-state actors that are involved, but unfortunately not all of them. So why do we need international criminal law? Because when everything else fails, maybe we can at least look for accountability in the aftermath of a conflict and provide victims with some type of redress, and maybe the whole system might develop as some kind of deterrent effect. So you could, of course, say, well, if there was a deterrent effect, then why do we have all those atrocities being committed? But the history of the enforcement of international criminal law is one of non-enforcement still, even if we have a certain situation where something was being done, but it's not all over the place. So the more activity we have, the more we contribute to a general idea of deterrence in the field.
Can you maybe still explain a little bit more, what do we have right now? I mean, we remember there was, after Rwanda, there was a special tribunal. We know that there was a special tribunal after the Yugoslav wars. And now there is something which we call the International Criminal Court, which is kind of still a new institution. I think it entered into force in 2002, if I'm not mistaken. So can you explain why the International Criminal Court became a reality, more or less?
Yeah. So almost 100 years journey for the establishment of an international criminal court, a permanent international criminal court that started sometime around the First World War. With ups and downs, a push after the Second World War, then very soon the Cold War kicked in, and there was little development in that time, and it needed indeed, I think, there were two factors that really pushed the development of contemporary modern international criminal law. That was on the one hand side, the end of the Cold War, which suddenly gave us a vision of how the UN system could work if we have willing states. And the second one was atrocities being committed in Europe, next doors. So without the conflict in the former Yugoslavia, probably we would not be in the situation that we have today. So the establishment of the two ad hoc tribunals in 1993 and 1994 for the former Yugoslavia and Rwanda were, of course, a major development with regard to having an institution that is competent to prosecute, and also with regard to the development of substantive law. The two tribunals applied customary international law. At the time, it was not really generally understood what is the status of customary international law. At the time, without the tribunals and the judgments, we still wouldn't know it. And thanks to quite some advancement, in particular in the early days, we are where we are at the moment. So this gave new impetus to the discussion of the establishment of a permanent international criminal court, with discussions starting outside the International Law Commission in 1995, and within 3 years we had a multilateral conference in Rome, the Rome Conference for the establishment of an international criminal court, that then adopted the statute in July 17th of July 1998, and it was quite an unexpected, fast entry into force process. You said it 2002, so only within 4 years the statute entered into force. So now we have a permanent institution with the advantage that one does not need to start discussing after a conflict whether there's enough political will and also the financial means to establish a tribunal. Ukraine can tell a story about that with regard to the special tribunal for the crime of aggression. So a permanent institution that is there, that can act quickly, that can already collect evidence and preserve evidence throughout a conflict and potentially have some deterrent effect.
Thank you. Ralph, you deal a lot with international law, but also international humanitarian law. But maybe before we go into that, following on the ICC, we remember after the Hamas atrocities and then the retaliation or war of self-defense, as Israel puts it, was highly contested by a couple of states, especially from the so-called Global South, because of the devastating effects it had on Palestinian, let's say, civilians there. We heard many super brutal, I would say, messages from state leaders from Israel, especially in the beginning. I mean, everything was in shock, etc. And then South Africa came up with actually appealing to the International Court of Justice and claiming that they should actually look into allegations that Israel might be committing a genocide there. Genocide is a very serious allegation, I must say, and it's very contested. Maybe you can reflect a little bit on what happened there and also tell us the difference between the ICJ and the ICC, because I do think that many people still tend to mix those two things up, and maybe you can then also already lead then again to the ICC with what the prosecutor has actually been coming up and the allegations he actually came up with against Hamas and Netanyahu and Gallant.
Just one word about what Astrid said earlier, because I love disagreeing with you, because then we argue for 30 or 45 minutes and then it turns out we don't have a dispute at all. So I don't think we do have a we do disagree here. I think that the system was still, I don't think it was designed for wars like this, but everyone knew that. Everyone knew that as soon as a permanent member goes to war, the system won't function. So everyone knew that. And it was just the birth defect everyone accepted, because the alternative would have been non-membership of the US, of the Soviet Union and the other victorious powers after World War II. So everyone knew that the system, maybe it is designed for wars like these, but at the same time everyone knows that the system would never work in wars involving one of the major powers, or nowadays no longer major powers, because France and the UK are obviously not major powers. So they just benefit from history. Going back to what you said, this is really important, because we have to differentiate, and that's why I'm so happy that you accepted my invitation. We really have to differentiate 3 different fields of international law. So that's why I don't like the statement when people say international law no longer works, because it's not actually true. We have to look at which subfield of international law, because international is fragmented. Which subfield are we really talking about? Are we talking about the jus ad bellum, the question whether you can start a war in the first place? I really think that the jus ad bellum is dead. However, are we then talking about the wars that are relevant during the armed conflict, international humanitarian law? I think here it's about to die, but it's not completely dead yet. It depends. Bad news from today, for example, another reason why I think that it's currently dying, I don't know if you heard the statement by the designated future Secretary of Defense, who is going to pardon war criminals. So that's a very bad signal for international law. If the future Secretary of Defense of the most powerful military in the world announcing that he will pardon people who have been prosecuted in the US for war crimes. Bad symbol and bad sign for the future of international humanitarian law, and also domestic criminal applying international humanitarian law. And that's the third question, and that's the one that I have for you, if I may say so. Whether international criminal law is also about to die. Whether it is currently dying, because the pivotal moment is you have arrest warrants, and then the US will use all it has in its arsenals to work against the International Criminal Court, if there are indeed arrest warrants and not merely applications for arrest warrants. Going to your question, having talked way too much about things that you didn't even ask, the International Court of Justice is the one where you have states, and states only. And here South Africa appears in its rhetoric as somewhat, you could say, the lawyer of Palestine and the lawyer of Palestinians. South Africa says we're acting on behalf of the Palestinians to prevent them from being subjected to genocide or at least have the genocide stop. I will not dive into the question whether that is actually genocide, but the argument of South Africa is to say South Africa is not directly affected, but indirectly it is, because genocide as the crime of crimes is relevant for the whole international community. However, at the International Court of Justice, there can never be individuals. The only time I've seen an individual being prosecuted at the International Court of Justice was in a Simpsons episode, where Krusty the Clown is indeed charged with crimes against clowndom. But that's a fictional scenario where they have mixed up the International Criminal Court with the International Court of Justice. Other episodes, none that the Simpsons or research errors by journalists, that unfortunately still happens, where I wonder, okay, so we worked on that, right? I've explained it to you on Twitter 100 times and you still make that error. Okay, so it's here to stay. But other than that, individuals will never appear in the International Court of Justice as individuals, but always as representatives of their states. Yes, it's not unfortunate, it's just it's not even a coincidence that both courts are in The Hague and they are very similarly named, but there is a huge difference whether you want to hold states accountable and individuals accountable. And what I find interesting is that the prosecutor did not charge any Israeli leader for genocide. He did not use what you could say from a policy perspective, nuclear option. Why? Because you have enough other crimes that are potentially being committed by Hamas, or actually committed by Hamas leaders and by Israeli officials. So you don't always need to use the full arsenal. There are enough crimes already. Same goes for Ukraine, Russia, by the way. You don't have to try to prove genocide because it's so difficult to prove genocide. There are enough other actions that fall under other articles of the ICC's Rome Statute, war crimes, crimes against humanity already. You don't always need to try to establish that genocide has actually been committed. And the third question I want to, third point I want to address here, the question of self-defense. This is the main justification for wars throughout history and since 1945, since the prohibition of the use of force has been enshrined in Article 2, Paragraph 4 of the UN Charter. At the same time, going back to the 1940s, no one thought of the possibility of having to refer to self-defense against non-state actors. Article 51 doesn't say an act occurs that has been, of an armed attack has occurred that emanates from a state, but implicitly and in the minds of the drafters, it was unthinkable that a non-state actor could carry out an armed attack. However, since 9/11, and you could say it should have even earlier, but at the very least since 9/11, that assumption has changed. Because 9/11, more than 3,000 civilians being killed in one or in a series of terrorist attacks, that changed the minds and that changed the perspective of international lawyers as well, because they realized, wait a second, even non-state actors can carry out an armed attack that is so severe that it can be compared to an armed attack by traditional states' armed forces. However, and that's one legal technicality where you can really see how policy arguments mix with legal arguments, whether Israel has a right to self-defense. And I really hate addressing this point because your words are being misinterpreted the second you speak them. If I say that Israel has no right to self-defense and you make a cut here, I would be slaughtered and as an enemy of Israel, whatever. But the argument I'm making here is not that I say that Israel has no right, that Israel has no right to security or whatever. I'm just saying that since Israel is controlling the entrance to the Gaza Strip, it's not as simple to say that Israel has a right to self-defense, because the right to self-defense traditionally applies to attacks that come outside from territory that you control. So the right to self-defense does not apply, for example, if there is a terrorist attack inside of your own country. You cannot claim the right to self-defense under international law when it comes to attacks that stem from your own territory, from territory which you control. With the Gaza Strip, it's a bit more complex because the Gaza Strip itself is not directly or not 100% under Israeli control, but it is also not completely outside of Israeli control. That's why you have such a technical debate as to whether, in a technical sense, Israel can rely on the right to self-defense. And as I said, the problem here is that this is the technical debate. The political debate is completely different. The political debate is Israel has a right to security, but I would use different wording. I wouldn't use the right to self-defense in a legal sense here. I would say the right to self-defense in a political sense, yes. A right to security in a political sense, but the legal right to self-defense is disputed because of the special status of the Gaza Strip as being somewhat under control of Israel, but not 100% under the control of Israel. So please do not misinterpret my words. It's just two parallel debates. The legal one, the political/security related one. In a legal sense, the applicability of the right to self-defense disputed. In a political one, undisputed, at least as long as you don't ask someone from Hamas or Erdogan, for example, who said that Hamas is a freedom-fighting organization. But other than that, at least in the so-called West, the legal right to self-defense is undisputed. The main question is, how do you fight a war, not whether you fight the war. That is the main question. That's an international humanitarian law and international criminal law question, not a jus ad bellum question. But you have to ask all these three questions. Criminal law, are war crimes being committed? Humanitarian law, how does Israel fight this war? Jus ad bellum, is Israel even allowed to fight this war? These are the three subsets, these are the three questions that we have to ask when it comes to these conflicts. We have to speak in plural now.
Thank you, Ralph. I think that was very good for us kind of to picture it, what we are talking about. But if we go back now to criminal law, I mean, I think, at least for me, it came as a surprise, honestly speaking, that the prosecutor of the International Criminal Court, so now we're speaking about the individual responsibility of individual persons of committing crimes against humanity or crime of aggression. Maybe you can also elaborate on what actually are the crimes, because it's only 4. It's not a very extended list of what the ICC is actually persecuting. But for me, it was quite surprising that obviously not that there was a request for the Hamas leadership. I saw that coming, and I think it is also very fair to do so. But for me, it was surprising that at the same time, he actually also made a request for crimes against humanity, not for genocide, by the way, as well, to Netanyahu and his defense minister. So why am I saying this? Because I do think that many always have been interpreted that the work of the ICC has very much been focused on, let's so-called, countries of the so-called south of the world. And I actually looked at how many arrest warrants the ICC put out since its existence. It was 40 in total, and more than 33 of them actually against Africans. So it was only Putin is an exception, and then there is 3 people from in the South Ossetian War, and all the others were Africans. And now it's the first time that also 2 Western leaders, more or less, have been, I mean, there is not yet an arrest warrant, it's still a request. So this was kind of surprising for me. So how would you maybe assess the situation? So is there something like a politicization as well when it comes to the ICC? And maybe also the second question, when can the ICC become active? Like, does the prosecutor say, I start by myself, or how actually can they start actions? How is this functioning? So the court itself, if you understand my question. Yeah.
Yes. Maybe I didn't understand fully the first question. No, don't repeat it. In the way whether you think that it would be a politicization of the ICC if there were only arrest warrants against people not from the West, or is the politicization that now we have arrest warrants against somebody from the West?
No, not again. It was before very much perceived as something, as an institution, from the West against the South. And I even prepared a quote from the prosecutor himself when he actually said before, arguing for requesting arrest warrants, that main Western leadership came up to him and told him, this court has been built for Africa and for thugs like Putin, not for the West. So I think this is he said that in CNN, he himself said that. So I think that's a very, very strong argument to believe that, that it's very difficult for him actually to stand up to power, which is perceived when it comes even to the ICC to be more or less following Western ideas and actually being a court against thugs from Africa. Sorry to be that blunt. Wouldn't you say that this has been true, or would you challenge that?
Well, I hope that he didn't say that this was a position of the West. I mean, I do not doubt that there are certain states that would put a lot of pressure on the International Criminal Court, in particular the prosecutor. There have been recently, Fatou Bensouda only recently came out in public about the threats that she received when she opened the investigation, particularly from Hamas. I'm so sorry, from the Mossad. So there's huge pressure. And I'm sure that some of even the member states and also one or two non-member states are very active in trying to pressure, particularly the prosecutor, into various ways. But I would refrain from calling it the West as a total. So there was so much in your question. The argument that the ICC is a court that only focuses on Africa. So yes, the first situations were all in Africa, but interestingly, all those situations were also referred to the court by exactly those African states parties. So I find it a bit difficult to bring the argument that the ICC is targeting a certain region of the world when this region of the world asked the prosecutor, please come and prosecute our rebels. Just at the time, and of course the ICC would not accept the situation only one-sided. It always looks into the situation as such and looks at all sides. But at that time, there was no problem from African states. Yeah, the problem started when the ICC looked at leaders of states. And then I might say it doesn't really matter from where those leaders come. It would be the same outrage in any region of the world, because here it starts where it becomes difficult. No, we don't really mind if the ICC looks at lower level people, but states are concerned when the ICC looks at high level people. And this is exactly why we need that court. So that's one point. The other point, you mentioned the situation in Georgia, where we also had arrest warrants against persons from outside Africa, but I really don't like this distinction. Also, we don't really know what arrest warrants the ICC has issued, because many of them are sealed. So we don't really know. So one of the main achievements for me in the last 2 years was that the ICC actually looks into actions of a permanent member of the Security Council. Is there anything more that symbolizes standing up against power than looking into the action of a P5? So I think it's slowly, the ICC needs to deal with all the criticism. There's standing, but it's in a politicized world. I wouldn't say that the ICC as such is politicized. Hopefully they're applying the law. Understandably, this is difficult when the ICC is under pressure from different sides, but this does not necessarily influence the judicial decisions. Yeah, so I think that was one of the side points that you mentioned, and the question was...
No, but I think you already answered part of it, because also said, when can it become active? And I think it's very important that you say, it's actually those African states requesting the ICC actually to do something about it. So this is also like, when does it become active? And it obviously makes a difference when it comes from African states.
Yeah. Maybe complete that.
Yeah.
So the ICC can become active if a situation is referred to the court. And a state party can refer a situation to the court, the Security Council can refer a situation to the court, and the prosecutor can become active on his or her own initiative, proprio motu. So in this situation in Palestine, the prosecutor started to become active, but that did not reach the level of a formal investigation where the ICC would have needed to address the judges and ask for an authorization to open a situation. But Palestine got a bit It took too long. They got a bit impatient, so they referred their own situation to the court. So there would be an official reason that the prosecutor would speed up in opening an investigation, because you don't need to have the judicial process. There's no judicial oversight over the opening of an investigation when it's referred to the court. Maybe in that context, I would like to add that a few years later, actually last year, at the end of last year and beginning of this year, we had further referrals of the situation in Palestine by a number of states parties. South Africa was part of it, Djibouti, and then also Mexico, for instance. So there's no legal effect of those referrals, because the situation was already referred and the prosecutor had already opened a formal investigation into the situation in Palestine. But you can see that it was, of course, a political support that was expressed by those states, and also to maybe heighten the pressure on the prosecutor to proceed in this situation. The idea was to achieve something similar that was achieved with regard to the situation in Ukraine, when 43, I think, states parties together referred the situation in Ukraine to the court. But at that time, it was indeed to give the legal justification to open an investigation. For Palestine, it was not necessarily necessary, but still there was political support and that came with it.
Maybe just one additional question, because I think it's very interesting, and I think many people also do not really understand what it means, you know, if the ICC is becoming active and if there would be, for example, an arrest warrant. And I think it's also, we need to understand it has not yet been the case when it comes to Netanyahu and his former Minister of Defense. I mean, it's still only the request, so it takes some time actually to go there. But if there would be something like an arrest warrant actually issued by the ICC, because we do know that, for example, Israel and the United States and also Russia, like many big important countries, they are not part of the Rome Statute. So what in effect actually does it have? What would you say? What is the outcome?
The outcome of the arrest warrant is that you have a person that is being sought by the court, that you have an arrest warrant. So with regard to jurisdiction, which might be one part of the question, it doesn't matter whether the state of nationality of an alleged perpetrator is a state party to the ICC, because the ICC, at least in part, operates on the principle of territoriality. So if crimes are being committed on the territory of state party. In the case of Palestine, it would be the state of Palestine. The ICC can exercise its jurisdiction, and then it doesn't really matter what the nationality of the alleged perpetrators is. If your question is more with regard to the actual prosecution and trial afterwards, it's of course extremely difficult, because the ICC does not have police forces. They cannot go into a state and arrest someone. They are always dependent on the cooperation of states. So it's very unlikely, at least in the near future, that Benjamin Netanyahu or also President Putin would be surrendered to the court. But first of all, it might happen. You don't know. Second, I think it's also, at least symbolically, it's an important step in upholding the rule of law, that when it is understood that crimes may have been committed, and at least the standard that we have with regard to arrest warrants is a reasonable basis to believe that a certain person has committed certain acts. This is a document that is being issued by 3 judges. The prosecutor went through it. It is being reviewed by judges, and judges issue a warrant of arrest or a summons of appear. That's quite an important step, I think.
Thank you. It's exactly what I wanted to hear, what the effects actually are. Thank you for that one. Maybe, Ralf, if we go back to what you said before, that there is something, you discussed a little bit the right of self-defense, but however you may call it, nevertheless, when we talk about international humanitarian law, I think it would be important also that you explain us a little bit what actually does international humanitarian law mean. Even if you would have the right to self-defense, you cannot do it limitless, right? I mean, what is actually international humanitarian law in the sense of whenever a war is happening? What does it mean?
Yeah, that's also, for historic reasons, a very, very different differentiation. So a very difficult and important differentiation. So we have a situation, and that's also increasingly being challenged, by the way. But the main argument is to say, even if you're lawfully defending yourself, even if you're fighting for survival, there are certain limits. Where these exact limits are is not as clear as it should be. So, for example, if you just think of the Nuclear Weapons Advisory Opinion, there you have this somewhat contradictory statement by the International Court of Justice saying that nuclear weapons are always violating two core rules of international humanitarian law, and the two core rules are, and that's why I'm mentioning this advisory opinion, principle of distinction, never target civilians directly, and do not cause unnecessary suffering, even if you're targeting someone who is a legitimate military objective. And then, however, at the same time, the court back in 1996, by the way, said, so nuclear weapons always violate international humanitarian law because they cannot differentiate between a civilian and a combatant or other legitimate targets, civilian targets, military targets. Plus, they cause unnecessary suffering. Maybe you know some of these movies or short clips, the one produced by the Foreign Ministry, as to what the impact of a nuclear weapon is. It's bad. And at the same time, the court then said, but we do not know whether a state may use a nuclear weapon if its very survival is at stake in an extreme situation of circumstance. Although the court gave it the answer itself by saying that it will always violate international humanitarian law, so it's always unlawful, but then it said, but what if there is an extreme situation of circumstance? For example, if Ukraine had kept its nuclear weapons, and also if it additionally had control over the nuclear weapons that were located on Ukrainian territory. Could Ukraine now, since it is facing an existential threat because of the severity of the attack of Russia, could it lawfully use nuclear weapons against Russia? We don't know for sure. ASTRID might disagree, and then we discuss for 40 minutes, and then it turns out we do not disagree. But long story short, these are the two core rules. In theory, that's quite easy, because the basic idea of humanitarian law has always been, and that's also why there is a dispute. You could say a philosophical dispute between Henri Dunant, the founder or one of the founders. He's not the only one. He's just the only one that everyone remembers. One of the founders of the International Committee of the Red Cross, who say wars are bad, but at least we can then make them less bad. We will not ban them, however. And then you have Immanuel Kant with the basic idea, wars are bad, so we have to do what we can to prevent wars and establish perpetual peace. In humanitarian law, the basic idea can be summarized in one sentence. They exist, but at least we can make them a bit less bad for those affected by it. Both soldiers, both fighters, and civilians. And now applying that, these fancy one-sentence, two-sentence statements, when we apply them to actual conflicts like the one in the Middle East, we have a problem. Because we have the problem that you have on the one hand one actor who does not adhere to international humanitarian law at all, and we have another actor that uses this non-adherence as a justification for its behavior. Because Israel now routinely refers to the presence of Hamas fighters in civilian buildings and says this justifies attacks on hospitals and on schools.
May I ask,
yeah.
But doesn't this also blur the line then,
Which one?
The distinction line between civilians and combatants?
That's the essential problem.
Yeah.
Because international humanitarian law, in an ideal world, it means you fight a war on a remote battlefield far away from civilians. That's the cabinet wars scenario you had in the 18th century. Then you had the problem, Napoleon, mass armies, and you no longer restrict wars to remote battlefield far away from civilians. And now you have the extreme scenario where you would say, okay, you mix and you deliberately mix civilians with military objects. But that by itself is not only a prerogative of Hamas. I mean, just think of Marie-Hilfer-Straße, right next to Marie-Hilfer-Straße, you have, if there is a conflict between Austria and any other country, you have a military target right next to Marie-Hilfer-Straße. You have a military installation of the Austrian Ministry of Defense. Or, if you live in the 13th district, You live right next to the Maria Theresian Kaserne, the one where I served when I had to do the compulsory military service. It's right next to a civilian area. So that by itself is not completely, that's not only a Hamas feature. The extreme feature of Hamas is that they purposefully mix and blend with the civilian population and use the civilian population as a human shield. But ideally speaking, you would have all military installations far away from civilians. Most states that I know of, also in Munich, for example, the military academy is also not completely far away from civilian objects. Ideally speaking, it would be. In practice, that's not always the case. The problem with Hamas is that they blend with civilians. The subsequent problem with Israel then is that they routinely can always say, well, they're blending with civilians, so the Al-Shifa hospital is a legitimate target. You have Hamas leaders being in civilian objects. We want to target Hamas leaders. So everyone who is close to them, you're to blame, or Hamas is to blame. Or when we extend to Nasrallah, the killing of Nasrallah, they simply said, such a high-value target that it justifies the killing of many civilians. And this is then not only a purely legal discussion, it's an ethical discussion. How many innocent lives can be taken, how many innocent people can be killed to kill someone who is not innocent? In the higher that military target, and this is a radical utilitarian question, because it simply means, does one Nasrallah justify the killing of 10 innocent civilians? 20, 30, 50, 100? How many? There is no clear legal answer to that. We only know that it doesn't justify everything, but how much the killing of a high-ranking military leader or terrorist leader, how many civilian killings that justifies, we don't really know. And there can't be an objective answer. In extreme cases, yes, you can't kill 10,000 people to kill one leader. But other than that, 100 civilians is okay, 50, 10, ask yourselves. I don't have an answer. Maybe you have one for yourself, but I don't think actually that there is an objective answer, leaving aside clear-cut cases. Because the question is, always is, how valuable is the life of a civilian when you compare it to the life of someone who is not innocent?
But maybe that also shows us already the limits of also international humanitarian law, because if you take up the example of Gaza, which is a densely populated area, and you then more or less say, civilians are there and Hamas can be there all the time, and so you can justify with the same argument more or less, which is international humanitarian law, to flatten everything around it, right? So you actually use international humanitarian law, the human shields argument, to be able to flatten everything, right? Especially in densely populated areas. So it becomes very, very difficult actually to get out of this somehow.
That's one very important point I want to make, since you mentioned it. And that's a very, very delicate subject, but we tend to forget that maybe you shouldn't call it humanitarian law, because at the end of the day, it's not only humanitarian. It also has a dark side. The dark side is it gives you a license to kill. It gives you a license to kill people. Everyone wearing a uniform, everyone who is a combatant is a lawful target 24/7, even during sleep, even when on holidays away from the battlefield. Second, it also gives you a license to kill, not directly, but indirectly innocent people, as long as you are not carrying out a disproportionate attack. So the international humanitarian law is not that humanitarian. That's why I no longer like the term, because it also justifies things that are, for some, at least if you're an idealist, unjustifiable. And we tend to forget, and that was also a point that Israel has routinely made. They always said, we are above the minimum standard. We did more than we had to do. And if you look at for example, Germany, they said, if we would fight a war against Hamas, we would probably fight the war just like Israel does. So does that mean that they do not care about international humanitarian law? Or does it mean that international humanitarian law is not as humanitarian as we want it to be? There is a dark side to it, and the dark side is it justifies killings and it justifies destruction. The real question is how many killings of whom, and how much destruction.
Thank you. I have a last question before we go into the public discussion, which drives me back to the topic of the whole discussion, which is dead or alive, international criminal law. If you look at what is happening all around the world, and if you also see that some countries have been, I think, retreating, and I think also the sanctioning, as far as I remember, there was also the prosecutor did not get a visa to enter the United States, or did I get something wrong at one point, you know, so that there is a lot of pressure on those people trying to uphold international criminal law. How do you see the future of international criminal law? Is it dead or is it alive?
That's a very big question. You asked that before as well, right?
Prepare, Ralph. The same question goes for you afterwards.
Well, I could say, you know, I'm amongst the international relations people here, and I'm not one of them. So I will look at the legal framework, and then, I don't know, dead or alive, they're there, they're institutions, they're going to stay there. There might be waves of relevance and of activity where those institutions can do more or less. The law is certainly there, it's not going away, and I don't see either jus ad bellum or jus contra bellum. Actually, what you're saying is that jus ad bellum is starting to get alive and jus contra bellum is starting to die. I don't see it that way, particularly after the Russian invasion into Ukraine. If you look at state reactions, and of course you have the very clear and strong reactions in the European context, but even if you look at the criticism from the global South, pointing out the hypocrisy that now we are suddenly interested in the prohibition of the use of force, but we were not before. But that also says that the jus contra bellum is not dead, because those states want it to be applied. So no, it's there. Hopefully it will be applied. We have a long history of non-application. It will not change from one day to the other. And in the end, it always depends on the states, how willing they are. And even if you have one actor that is particularly protected or is a very high power actor, it always depends on how serious the other states take it and whether they build a common front or not.
I think that's a very valid point, that it really depends on the will of states, and that many states actually still try to uphold it. And even when it comes to the ICC possible arrest warrants, I mean, we're going to see that even Germany said they're going to uphold it. So, which means if Netanyahu or Gallant would travel to Germany, they would need to arrest him, essentially. So that is at least what they have been saying. Ralph, same question, dead or alive, international humanitarian law?
About to die. Sadly enough, because also what is being foreshadowed by the new Secretary of Defense, like all these announcements, and he also said that women are not fit for battle. He will end all these inclusion programs, and men have to fight again, and they should be able to fight unhinged, going to pardon war criminals. Also, when you look at Israel saying that, look, if we want to fight a clean fight, according to the highest standards imaginable, we won't be able to fight in Gaza, because that was also an argument. And some said, look, even if you ask us to fight a war without any civilian deaths or without any disproportionate civilian deaths, we couldn't fight at all. So here, the jus in bello would then contradict the jus ad bellum. Even if you have a right to defend yourselves, but if there is no way of defending yourself in a clear manner, then it means that you can't, logically speaking, defend yourself. So that's also, whenever a state feels threatened, and that's not a prerogative of Israel, it's for every state. Whenever a state feels threatened and is afraid of being extinguished, because that's the inherent, we sometimes forget it in Austria because we're surrounded by friends. In Israel, it's the other way around. It's surrounded by enemies. Even those states that have peace treaties with Israel, they know that maybe they have a friendship treaty with the government, but they know that the population is not a friend of Israel. So being surrounded by enemies means that Israel always says we have to, and also that's a point that policymakers are often making, it's the Middle East. In the Middle East, you have to show strength. The first time you show weakness, they will exploit your weakness. But that also means that this strength doesn't want to be restrained, or not too much at least, by international humanitarian law, or also, and definitely not the jus ad bellum debates. concerning use ad bellum or use contra bellum, my counterpoint, and I think we're really disagreeing here, we have to differentiate between words and practice. Yes, when you look at the General Assembly resolutions on the war against Ukraine, an overwhelming majority voted to condemn the Russian aggression against Ukraine. However, there was for my taste, way too many states, not a majority, but way too many states who simply didn't say anything, who didn't even disappear. It was only 142 states, if I'm not mistaken. UN has 193 members. So what about these 50 states that didn't say anything? Or only a small number agreed with Russia. Only a few states sided with Russia. And governments, more precisely speaking. Syria, Nicaragua, Eritrea, Belarus, and North Korea, if I'm not mistaken. So 4 to 5 states, not much. But a relatively large number of states didn't say anything, first thing. And second, you have a lot of opportunists. If you look at practice of India, China, they're saying, oh, great. The Europeans are no longer buying raw materials from Russia. We're going to buy them at a cheaper price. If they were so keen on upholding the use contra bellum, they would adhere to the obligation defined in the ILC Articles on State Responsibility that says states have to cooperate to bring severe violations of jus cogens to an end. And I don't see that at all. I see that in Europe, in the West, yes. But where are the sanctions by India? Where are the Chinese sanctions? Where are the Brazilian sanctions? There are none. So we have to look at two maps. One is the map of statements, but the other map is the one of practice. The map of statements and of votes in the General Assembly is quite convincing. Not as convincing as it should be, but quite convincing. But the map of countries that have imposed sanctions on Russia is a very Western map. The rest of the world doesn't care because they say, we're opportunists. We get cheaper Russian oil. We get cheaper Russian gas. Or we get good connections to Russia as the leader of the counter-Western alliance, whatever that is. But when it comes to putting words into deeds, I don't see enough state practice to prove that there is a jus contra bellum. I think the jus ad bellum, that's very important difference that you made. The jus ad bellum means the right to start a war. The jus ad bellum, the right to war. We have in legal theory a jus contra bellum, a right or a law against war. But in practice, I don't see it being implemented, or at least not the way it is as it should be.
You wanted to react quickly, yeah?
Just,
sure.
So I don't dispute you in that, but I dispute that this necessarily has an impact on the law. Yeah, so this is international law, isn't it? We have a law and it's not always implemented, but that doesn't mean that the law disappears as long as it's being upheld, even rhetorically. Yeah? So that's my international law. Last point.
Yes,
thank you.
We can already prepare for questions, although I must say, Ralph, I do have also, to follow your argument, we remember also that South Africa actually said that they're not going to arrest Putin if he would join the BRICS summit there, and South Africa is actually part of the ICC statute, as far as I do know, and this is the country, you know, like being now championing the genocide allegations against Israel. So following in your argument in this one, but
it's also the country with an enormously strong civil society and a judiciary system that actually at another occasion said, well, of course we need to, at that time, surrender President al-Bashir to the ICC. Yeah. So within the countries, you have the executive and other powers which are not always going the same way.
I think that's a very important point. Thank you for that. Ralph and Astrid, thank you so much. I think it was a wonderful discussion about a very heavy topic, but I hope we managed to shed a little bit of light on what ICC is doing, what ICJ is doing, what international humanitarian law is and what it is not, that it is not as humanitarian as it maybe ideally should maybe be, and that it can be instrumentalized and everything else can and everything else also is. Thank you so much for coming tonight. I hope you enjoyed it as well, and if you don't want to run away, we also prepared some water and wine outside, so if you still have the feeling you need to discuss, I hope you might stay for a couple of minutes more. If you have been shy before, don't be shy now. You can still approach them and ask the very tough questions you didn't dare to ask before. But thank you so much for coming. Thank you again. It was a real pleasure.